Hello again! I have recorded a few videos, but now that work is back in the full swing and everything, I'm gonna be honest, it's just really difficult for me to stay on top of news as it comes out. So what happened? I got really ill. I'm working on a few videos that are closer to getting out about like some small, not very important things like RuPaul's Drag Race. Wondering if anybody here likes that. But of course, when I was coming down with the illness, I was recording a video about like the current court documents at the time, and like I actually had to stop recording the video because I was getting so coughy. And so I recently recorded the second half of it, but it's like that was almost a month ago now at this point. I was really sick and really down for the count. In all truthfulness, I am still recovering. I will likely be stopping this recording a lot to drink, but I was really down for the count, and I think it's just easier for me to do this on the fly as things kind of come out. Try my best to keep up that way, and if I can get around to editing those like past and behind recordings that I have, I'll put them out, and then they can you can listen to my retroactive thoughts on something. But it lacks relevancy, and I think I feel bad not having anything out. It's like I have all these like half-cooked things out there, and I can't put one out. So I wanted to touch on something that was recently uploaded to the Justice for Clayton subreddit last night, I believe. That would be Monday, January 22nd. And basically, this is the most recent filings from Greg Woodnick and Isabel Ronnie, of Woodnick Law, who are the representatives for Clayton. This, I believe, was filed on the 19th of January. So I'm just going to dive straight into it. We're going to read through this. Respondent Clayton Echard, by and through undersigned counsel, hereby provides his response and objects to petitioner's unverified. Okay, side note, I'm going to try not to do this too much in the middle of a sentence, but if it happens, it happens. The underlined is just already giving me like Petty King vibes, and I'm just dying. Unverified motion for confidentiality and preliminary protective order. As a threshold matter, petitioner's requested relief under Rule 53 constitutes an underlined impermissible prior restraint of protected speech. And we know Miss Laura Owens loves to restrain protected speech. Beyond that, it also represents tremendous overreach in the use of Rule 53 to diminish respondents' rights as a litigant. That's what it reminds me of, Apparently, petitioner feels she is entitled to what is essentially a backdoor motion to seal after this court already denied her attempt. See minute entry dated 10/19/2023. Why? Because after she contacted tabloids and the media to disparage respondent, the publicity she initiated backfired when it was exposed that she had engaged in previous pregnancy fabrications, that her quote-unquote medical evidence was lacking in science. Oh my god. This is like straight fucking fire so far. I'm loving and living for it. The entire underpinning of her petition to establish paternity was predicated upon a con/scam and fraud upon this court. Petitioner has furthered her noxious, oh my god, I love it. I love it. Her noxious agenda by failing to appear at a properly noticed deposition that was filed on January 17th, 2024. In past news, she missed a deposition that had been scheduled. This occurred notwithstanding 3 different attorneys in a matter of weeks having discussed the deposition and ongoing discovery issues. Meanwhile, she continues to advance meritless lawsuits against the media for questioning the narrative she shared with The Sun while simultaneously contacting the media. I love all the all the hypocrisy that he's calling out right now. It's just so good. It's so delightful. This is very much just like tasteful bitching out, and I love it. Now, petitioner has the chutzpah to flout court rules and suggests this court ignore the First Amendment, while in the same breath arguing that she is entitled to protection by the court. Thank you. Another one, thank you. Every sentence, just a banger. Just flawless. To the extent applicable, respondent incorporates his pending filings. As and for his response/objection, respondent states as follows. 1. Currently pending before the court are: A. Respondent's motion for leave to amend respondent's response to petition to establish. B. Petitioner's motion to dismiss, filed December 28th, respondent's response/objection to the same, and respondent's reply. Ostensibly, this matter has been ruled on as the docket reflects evidentiary hearing set for February 27th. C. Respondent's expedited motion to extend dismissal date on inactive calendar and schedule an evidentiary hearing filed December 13th, and petitioner's response and respondent's reply to the same and ostensibly addressed by this court setting the matter for an evidentiary hearing. D. Petitioner's expedited motion to quash deposition of petitioner filed January 1st. Damn, they were right on this first of the fucking year. And respondent's response/objection to the same. Respondent's motion for sanctions is point E, pursuant to Rule 26, filed January 3rd. 2. The court must begin with the presumption that prior restraint on protected speech is dubious and subject to the highest scrutiny. Bolded. Petitioner does not address or even attempt to explain why prohibiting respondent from speaking about the issues she brought in the action would withstand constitutional scrutiny. This is not the least restrictive means to accomplish the end stated, nor do the concerns petitioner express outweigh the substantial interests of respondent's freedom of expression, freedom of the press, the public's interest in open legal proceedings, etc. Petitioner's demand would trigger a woefully unnecessary and inappropriate procedure overtly designed to thwart disclosure. Recall that she has entirely failed, underlined, to comply with Rules 49, Rule 62, Rule 57, Arizona Rules of Family Law Procedure. Petitioner has not shown good cause for deviating from the ordinary process for petitioning the court for confidentiality or sealing documents when the court deems it appropriate. Here, she seeks to hide behind Rule 57 as a justification for willfully failing to attend a properly noticed deposition and for continuing to fail to provide any disclosure going on 8 months. Meanwhile, initiating contact with the media, publishing articles, and otherwise soliciting media attention. Blow. That part right there, that in lights, put it in a fucking billboard. I want her to see it every day when she leaves her little casita. Page 4, point number 3. The fact that discovery may annoy or embarrass petitioner does not mean that sealing and confidentiality are appropriate remedies. Petitioner not only brought this action in bad faith, and also she shared it with the media and even wrote a de facto op-ed furthering her fictitious narrative, painting herself as a quote-unquote victim. Absent from petitioner's motion is that petitioner filed the underlying action. Petitioner threatened repeatedly to bring her alleged quote-unquote pregnancy to the media. Petitioner reached out directly to the media with her unsupported allegations. The Sun, People Magazine, TMZ, Reddit, and Medium. And petitioner published information including her alleged medical records about the case online. Wild. Petitioner now continues to contact the media to advance her fictitious narrative while simultaneously asking this court for special accommodations for confidentiality. This after the court already denied her motion to seal. Parenthetically, petitioner's efforts to seal the other case with nearly identical claims of being pregnant with quote-unquote twins and with similarly doctored sonograms was also denied seal protection. Her conduct and legal positions simply do not align. This is what I was talking about when I said, like, there's a dissonance between, like, what she says and what she does, and if she were really pregnant, how a lot of this shit doesn't line up. And I love this because, from what I'm understanding, I don't know if these lawyers have been representing Clayton, but I do know that this law firm represented Greg Gillespie, which is her most recent victim before, or that we personally know about, before Clayton. And I am just feeling, oozing from this letter, this guy, Greg Woodnick, who owns a law firm, is so done. So done with her. It is so refreshing to just see someone go balls to the fucking wall over this. Bolded. Petitioner is not special. Respondent does not doubt that petitioner will be annoyed or embarrassed by examination by oral deposition. Well, maybe you shouldn't do annoying or embarrassing shit. Huh? Mind-blowing, I know. But if that were the legal standard to oppose a deposition, the exception would swallow the rule. Every litigant is uncomfortable being examined under oath. That is inherent to the adversarial system that petitioner triggered with her filing. It is only when those burdens are undue or the discovery process is abused that those concerns become sufficient grounds to prohibit discovery mechanisms. All litigants are entitled to the use of discovery for legitimate purposes, which includes gathering information, testing the deponent's knowledge, knowledge and truthfulness, exploring patterns of past behavior, including other fictitious pregnancies, appearances under oath in court with a fake pregnant stomach, collateral proceedings, etc., and other acts relevant for impeachment and or to show that the underlying cause was malignantly filed. Moreover, petitioner cannot now evade deposition, critical for establishing evidentiary foundations after she invoked Rule 2. The fact that petitioner finds participating in the litigation embarrassing is no different from the experience of anyone else, except that in this case, she brought the petition, she made sensational allegations, and she threatened to, and did, bring media attention to the case in an attempt to control respondent's behavior and, disturbingly, to get him to sign a dating contract and coerce him to explore intimacy with her. See Exhibit 2. Not only is respondent entitled to the information and discovery necessary to defend against her claims, but he also has a fundamental constitutional right to discuss the nature of those claims, just like any other litigant. Petitioner is requesting an order that would prohibit respondent from defending his character in public view, despite the fact that she made his character a matter of public interest and that she self-identifies as a public figure. We went on about that. The toothpaste cannot be put back in the tube. Moreover, that the public is interested in the case only adds weight to maintaining transparency, not limiting it, even if petitioner now finds that the interest uncomfortable after she invited it. Banger. Just straight fire out of this dude. 4. Respondent has the right to depose petitioner pursuant to Rule 57, Arizona Rules of Family Law Procedure. That is not in dispute. Petitioner has provided zero Rule 49 disclosure to date and now files this unverified motion alleging for the first time that she had a miscarriage? ? Petitioner appeared on video during trial on October 24, 2023, wearing what appeared to be a moon bump, a device used to appear pregnant, and asked the court if she could show respondent her quote-unquote pregnant stomach, which Judge Gialketsis promptly denied. Note, the motion for protective order was filed after petitioner was copied with a spoliation notice to Amazon.com, Inc., to preserve records confirming the purchase of said moon bump and to affirm that babies come from intercourse, not Amazon.com. Oh my fucking oh my god, it's gonna put me in a coughing fit. That was amazing. That was fucking amazing. Dude, I'm fucking dead. On November 2nd, 2023, petitioner testified that she was 100% quote-unquote and 24 weeks quote-unquote pregnant by respondent and that she was due quote-unquote February 14th, 2024. Petitioner specifically testified that she was having a high-risk pregnancy due to her alleged epilepsy, and that she was being seen by Dr. McCool and Dr. Higley. To date, petitioner has provided no verifiable information that supports these allegations, other than doctored sonograms ostensibly from Etsy, a borrowed YouTube video, and an actual sonogram and positive HCG tests. Petitioner then filed a motion to dismiss, claiming for the first time that she was no longer pregnant, but still refused to provide any information whatsoever about what happened to the alleged twins' fetuses. Now, for the first time, she alleges that she quote-unquote miscarried. Convenient. That is a salient fact in dispute because respondent does not believe that petitioner was ever pregnant, and certainly not by him, as they did not have intercourse. Moreover, if petitioner did miscarry that late into a pregnancy, a fetal death certificate would be produced, and there would be corroborating medical records. Respondent has repeatedly asked for this death certificate and even provided the vital records request forms to petitioner. See Exhibit A to respondent's notice of non-appearance as deposition pursuant to Rule 57, filed January 17, 2024. Due to petitioner's historic refusal to provide any medically verifiable information to support her allegations and her history of arts and crafts quote-unquote medical evidence, written discovery is not sufficient. She does not dictate which discovery rules apply to her. All bolded, bitch. A deposition is the most efficient and least burdensome way to ascertain the validity of petitioner's claims under oath. Her fear of inculpating herself criminally, perjury, filing false police reports, etc., is the antithesis of good cause. Did you hear that? People in the back, did you hear it? Limiting respondent to the quote-unquote alternative means of discovery referenced on page 6 of petitioner's motion would incapacitate respondent's ability to obtain relevant and necessary evidence. Ironically, petitioner also requested respondent's deposition immediately upon hiring her current attorney, i.e., before taking any other action to address the supposedly burdensome discovery. Petitioner first retaliated by scheduling respondent's deposition. Petitioner cannot have her cake and eat it too. Oh my god, I love it. I love it. Shady queen. 5. Respondent is entitled to depose petitioner about all relevant matters, including similar fake pregnancy allegations made against past putative fathers and inconsistent statements admissible for impeachment purposes. Not only do those allegations speak to her credibility, but they also establish an overt and escalating pattern of fraudulent behavior and abuse of legal process. Respondent cannot properly bring his counterclaims of non-paternity sanctions and attorney's fees without deposing the petitioner and receiving definitive statements under oath about her past actions. The scope of inquiry absolutely includes relevant questions about past relationships that resulted in similar threats and legal actions brought by petitioner in writing in prior litigation, emails and text messages she sent to other men with nearly identical verbiage, prior doctored quote-unquote evidence, factually similar matters about which petitioner authored editorials, TEDx talks, podcasts, and petitioner's medical and associated health conditions. After discovery, nothing prevents petitioner from seeking confidentiality or other appropriate protective orders as to limit portions of the deposition if the court were to then determine they exceeded legal scope. However, preventing those questions from being asked in the first place would improperly limit respondent's ability to defend himself and stymie this court's ability to make findings pursuant to the law. In addition to the misuse of court procedure, there are significant First Amendment concerns here. Prior restraint against relevant discovery is an extraordinary remedy that is not remotely warranted in this matter. Petitioner has not shown good cause to override respondent's legal rights, the public's interest in transparent proceedings, and this court's legal and equitable duties. Petitioner's prospective concerns, after willfully failing to comply with court rules for 8 months, are nothing more than an opaque attempt to thwart this court's ability to make findings. Petitioner cannot simply seek generalized and speculative relief as a means to justify a blanket restriction prior to providing any discovery / participating in a deposition. Moreover, her objections are not valid grounds for a willful failure to appear for a validly noticed deposition. See respondent's notice of non-appearance. 6 on page 8. It is premature to designate as confidential documents, recordings, or records that do not exist and have not yet been produced. To the extent a response to this assertion is warranted, there is nothing to be designated confidential. No deposition has occurred. due to petitioner's willful failure to appear. Petitioner has not provided any Rule 49 disclosure, and there are no exhibits or sensitive documents in the court record that could be designated confidential, even if petitioner has shown good cause. Simply put, petitioner's request is impossibly premature, and the discovery being sought is relevant, including the HIPAA they're calling out her misspellings, releases referenced in her motion. Further, and contrary to petitioner's assertions, discovery cannot be conducted during trial. 7. Respondent is entitled to his reasonable attorney's fees and costs incurred responding to his motion pursuant. After properly noticing petitioner of his intent to dispose her and agreeing to a date and time, petitioner willfully failed to appear. Instead, petitioner filed this motion, which alleges speculative relief that cannot be granted, seeks unconstitutional prior restraints on protected speech, and lacks good cause. Petitioner's unreasonableness in this matter only persists as she continues to seek out new ways to evade the disclosure and discovery obligations for the actions she filed. Petitioner has a history of being creative and coming up with ways to avoid legal accountability. She previously made abhorrent allegations in prior proceedings involving similar false twin pregnancy allegations against an officer of the court to evade court appearances, fortunately foiled by Judge Bacchus, whose judicial assistant intercepted petitioner's ex parte effort, which was subsequently addressed in proceedings. As a result of petitioner's behavior, respondent continues to incur attorney's costs and fees having to defend his right to exercise the discovery tools available to all litigants. Respondent requests this court permit him to file a China doll affidavit. I don't know what the fuck that means, but I'll find out and I'll get back to you. Wherefore, respondent respectively requests that this court enter the following orders. A. Deny the petitioner's motion for confidentiality and preliminary protective order in its entirety. B. Award respondent his reasonable attorney's fees and costs incurred due to petitioner's unreasonableness pursuant to ARS 25-324. C. For such and other further relief as this court deems just and proper under these circumstances. Verification. Clayton signs off that he believes all of the above captioned matter to be true. Stay tuned for next video where I will read through the evidence. There is 63 pages in total to this document, and I just read 13 of them. Or 12 of them. 11 of them. So we'll go over the exhibits, but due to me still recovering from being ill, yes, I know, it's almost a month in, it sucks ass, I'm in the thick of it, sorry Charlie, I will have to break that up, but I'm going to try to get this out to you. Hope you enjoy it. I'm back in some capacity with limitations. I am not a YouTuber, so, you know, your girl has to make money somehow. There's so many bills to pay. Inflation's a bitch, and I'm trying to move, and there's a fucking housing crisis. Rent is up insanely across the board, so whatever I'm doing, I'm basically going to have to commit to paying double what I pay now, which is just fucking... So what I'm saying with that is that your girl has to stay on top of her job. But I'm recovering. Thank you for watching. Hope to see you again soon. I'm trying my best. I hope you're trying your best too. Happy New Year. And I'll talk to you later, alligator.